Um, Counting uncounted votes in a presidential election, Bush versus Gore. On December 12th of 2000, for the first time in American history, the Supreme Court essentially decided who would be the next president of the United States. The events leading to Bush versus Gore. The presidential election of Tuesday, November 7, 2000, was one of the closest in American history. By early Wednesday morning, it was clear that the Democratic candidate, Vice President Albert Gore, had won the national popular vote, but the outcome of the electoral vote was uncertain. The presidency turned on Florida and its 25 electoral votes. Early on election night, the television networks called Gore the winner in Florida, only to retract their prediction later in the evening. In the early hours of Wednesday, November 8th, the networks declared George Bush the winner of Florida and the presidency, only to recant a short time later and conclude that the outcome in Florida, and thus of the national election, was too close to call. Totally remember that. On November 8th, the Florida Division of Elections reported that Bush had received 2,909,135 votes and Gore had received 2,907,351 votes. Florida law provides for a recount of votes if the election is decided by less than 1/2 of 1% of votes cast. Because the difference in votes between the two candidates was less than 1/2 1%, Gore immediately asked for a machine recount of the tally of votes in 4 counties: Volusia, Palm Beach, Broward, and Miami-Dade. On November 9th, Florida Secretary of State Katherine Harris declined to extend the statutory deadline for county vote totals beyond November 14th. By this point, the machine recount had narrowed Bush's lead to a mere 327 votes. Upon learning of the close margin between him and Bush, Gore petitioned and received permission to conduct a hand recount in the 4 counties in question. On Saturday, November 11th, Bush sued in federal district court to block the manual recount, but this request was denied. However, Secretary of State Harris emphasized that she would enforce the November 14 deadline and would not accept late recounts from counties in Florida. She said that the Florida elections statute required counties to report their votes within 1 week of the election unless one of the statutory exceptions was met. These included proof of fraud that affects the outcome of the election, substantial noncompliance with statutory election procedures, and a reasonable doubt existing as to whether the certified results express the will of the voters, or where compliance with deadlines is prevented as a result of an act of God or extenuating circumstances beyond control. The 4 counties submitted their responses and requested acceptance of late completion of totals. Harris denied each one. A suit was brought against Harris in Florida State Court to compel her to accept the time for the reporting of the results. On Friday, November 17th, the Florida State Trial Court ruled in favor of Harris. On November 20th, the Florida Supreme Court held a nationally televised hearing. On Tuesday night, November 21st, the Florida Supreme Court unanimously reversed the trial court and ordered that the Secretary of State accept hand recounts from the 4 counties if they were completed by Sunday, November 26th at 5 p.m. or Monday morning, if the Secretary of State's office was not open for business on Sunday afternoon. The Florida Supreme Court ruled that Florida Secretary of State abused her discretion in refusing to extend the deadline for certifying elections so as to provide the time needed for the recounts. The court said it was confronted with a conflict between 2 statutes. The one statute, Florida Statute 102-111, provides that local election canvassing boards must provide their results by 5 p.m. of the 7th day following the election. This law was amended in 1989 by 102-112, which provides that election results may be ignored and board members shall be fined if these deadlines are not met. However, another statute, 102-1664A, specifically allows any candidate to request a manual recount. This provision states any candidate whose name appeared on the ballot or any political party whose candidate's name appeared on the ballot may file a written request with the county canvassing board for a manual recount. The law provides that the written request may be made prior to the time the board certifies and returns, or within 72 hours after the election, whichever occurs later. The Florida Supreme Court expressly noted that these statutes conflict. The court relied on traditional rules of statutory construction, such as that specific laws prevail over general ones, and the more recently enacted law. So this is the analysis. Okay, such that the court relied on traditional rules of statutory construction, such that specific laws prevail over general ones, and the more recently enacted laws take precedence over the older one, and concluded that Harris erred in denying the extension of time for the counting. The Florida Supreme Court also said that a statutory provision will not be construed in such a way that renders meaningless or absurd any other statutory provision. In order to effectuate the law allowing recounts, the court concluded that time must be allowed in which to conduct the recount. The court said that the Secretary of State's refusal to accept hand recounts was wrong because it completely negated the statute that expressly provided for this. On Friday, November 24th, the day after Thanksgiving, the Supreme Court granted certiorari in this case and scheduled oral argument for the following Friday, December 1. In an unprecedented order, the court permitted the broadcasting of the oral argument immediately after it was finished. A few days later, in Bush v. Palm Beach County Canvassing Board, the Supreme Court remanded the case back to the Florida Supreme Court for clarification of its earlier decision. The U.S. Supreme Court, in a per curiam opinion, said it was unclear whether the Florida court's decision was based on its interpretation of the Florida Constitution or Florida statutes. The former apparently would be an impermissible basis for decision, while the latter would be acceptable, based on the U.S. Supreme Court's interpretation of federal election laws. On Monday, December 11th, the same day the court held oral argument in Bush v. Gore, the Florida Supreme Court issued a decision saying its decision was based on interpreting Florida statutes, not the Constitution. Meanwhile, on Sunday, November 26th, some counties asked for additional time to complete their counting. For example, Palm Beach County asked for 2 additional hours beyond Sunday 5 p.m. deadline set by the Florida Supreme Court, particularly because the state Supreme Court expressly had allowed the Secretary of State to wait until Monday morning before receiving the recount totals. The Secretary of State refused all requests for extensions. On Sunday night, November 26th, the Florida Elections Canvassing Commission certified the election results. Bush was determined to be the winner of Florida by 537 votes, and thus the winner of Florida's 25 electoral votes. On Monday, November 27th, Gore filed suit in Florida under the Florida law providing for contests of election results. Interesting. Cases went on. The trial court was November 17th. Supreme Court was November 20th. And this was their holding. And then it went to SCOTUS on like the Friday after Thanksgiving, and then it was remanded. Wasn't it remanded in a Supreme Court opinion? So Monday, okay, so let's see, okay, what about December 11th? I don't know when it was remanded, but I can see here that they're counting. The provision 102.168.3c provides that receipt of a number of illegal votes or rejection of a number of legal votes sufficient to change or place in doubt the result of the election shall be grounds for a contest. The statute authorizes a court, if it finds there are successful grounds for a contest, to provide any relief appropriate under such circumstances. On Saturday and Sunday, December 2nd and 3rd, a Florida state trial court held a hearing as to whether Gore had met the statutory requirements for a successful contest. On Monday, December 4th, the Florida trial court ruled against Gore on the grounds that Gore failed to prove a reasonable probability that the election would have turned out differently if not for problems counting ballots. The Florida Supreme Court granted review and scheduled oral arguments for Thursday, December 7th. On Friday afternoon, December 8th, the Florida Supreme Court, by a 4-3 decision, reversed the trial court. The Florida Supreme Court ruled that the trial court had used the wrong standard in insisting that Gore demonstrated a reasonable probability that the election would have been decided differently. The Florida Supreme Court said the statute requires only a showing of receipt of a number of illegal votes or rejection of a number of legal votes sufficient to change or place in doubt the result of the election. The Florida Supreme Court ordered the supervisor of elections and the canvassing board, as well as the necessary public officials in all counties that have not conducted a manual recount or tabulation of the undervotes, to do so forthwith, and tabulation to take place in the individual counties where the ballots are located. The Florida Supreme Court also determined that Palm Beach County, Miami-Dade County, in their earlier manual recounts had identified a net gain of 215 and 168 lawful votes for Vice President Gore, and that these should be included in the vote total even though they were reported after the deadline of Sunday, November 16th. Just hours after the Florida Supreme Court's decision, on Friday night, December 8th, the Florida trial court judge ordered that the counting of the uncounted votes commence the next morning and that it be completed by Sunday afternoon, December 10th at 2 p.m. The judge said that he would resolve any disputes. That's what the trial court judge ordered, so I guess it was remanded, on remand. On December 8th, okay, with a deadline December 10th. On Saturday morning, counting commenced as ordered. At the same time, Bush asked the U.S. Supreme Court to stay the counting and grant certiorari in the case. In the early afternoon on Saturday, the Supreme Court, in a 5-4 ruling, said, Saturday, the Supreme Court said, is this SCOTUS? In a 5-4 ruling, stayed the counting of votes in Florida. Justice Stevens dissented on grounds there was not an irreparable injury, which is a requirement for such stay. Justice Scalia wrote a short opinion not joined by any other justice, in which he said the requirements for a stay were met. He said that Bush had shown a likelihood of prevailing on the merits and also irreparable injury. Justice Scalia said there were two such harms. First, there would be a cloud over the legitimacy of the Bush presidency if the counting showed Gore ahead, but the counting was disallowed by the Supreme Court. Second, handling of the ballots would lead to their degradation and prevent a more accurate counting later if that were ordered by the court. On Monday, December 11th, the Supreme Court held oral arguments. Again, they were broadcast immediately after their completion on Tuesday night, December 12th, at approximately 10 p.m. Eastern Time. The court released its opinion in Bush versus Gore. And so the case starts on page 1143. That was just the background. This was per curiam, which I think means that the entire panel of judges of the Supreme Court, provided an opinion. The case goes on until with dissenting and concurring opinions until page 1162. which I'll start shortly.